Okay, there we go. Good morning, good evening, and of course, good afternoon, everybody. Welcome to our Lunch and Learn, the Versus Virus Incubator's Lunch and Learn. Today, we have a very special guest. We have Thomas Hua from GBF. He's an attorney at law, and he's going to share with you what are the legal considerations when establishing a venture. Thank you so much for all the questions you sent. Thomas has been looking at them. He will be answering the common questions. For the rest, you'll get in touch with him personally. Well, Thomas, welcome. How are you?
I'm very well, thank you, Biliana. Thank you for this glowing introduction. Very happy to be here, of course, to be sharing a bit of knowledge, hopefully that can be useful to the participants.
Beautiful. Well, I would suggest you share your screen and you take it from there. We are all ears.
And let's go for it. Can everyone see my screen? Is that okay?
Yeah.
All right. So today we'll be talking about some practical considerations for creating and developing a startup, mainly in Switzerland, Swiss-oriented, with some legal knowledge, but also certain, perhaps, a bit bootstrapping tips if they can help. Given the questions I've received, I prepared something around 3 themes mainly. For one, the legal entities, how, when, why to create a legal entity, what type is the best, what is the best type entity for your project. The second part is a bit more on equity or financing in general, and a third part, a very brief introduction on intellectual property. These will be the three themes. Although I put a section for the questions, feel free to just chip in. I don't mind being interrupted. Just trying to get the chat box to pop up again. I'll do that afterwards. But feel free to just pop in or raise your hand somehow to say I have a question, and we'll try to deal with them as we go. Here we are. Now, incorporating a legal entity. We have a lot of questions saying, well, what is the best legal entity for me, for my project? Now, I'd like to start perhaps with a different question, which is the question of why. Why should we even bother to create a legal entity? Why is it useful in the end? well, so many people are doing it, there must be a reason, right? Now, the reasons are various. I'd say one of the foremost reasons creating a legal entity is certainly to improve the credibility in terms of partner, customer, or stakeholder relations. It shows that the persons behind a certain project are fully committed, they have made the effort of creating a legal entity, and that they are actively doing what they're doing. Now, of course, the mere act of creating a legal entity is not going to make a startup famous overnight. It is but one of many elements that a startup needs to do to before it can be recognized, enter the market, and start shaking hands and signing contracts. Amongst the other elements, what you could think of is, of course, naturally the website, a trademark. We'll say a bit more about that afterwards. A trademark is actually quite a smart and important step for startups, at least those who are, I'd say, in the B2C, but also in the B2B area. Generally, a trademark is always a good idea. These are the kind of things that will establish credibility for a startup when you've just started. The second thing, and I'd say from a legal perspective, it is the most important thing. It's what we call the limited liability. What does it mean in concrete terms? Well, it means that if I start an activity, any business, I start producing something or selling a service or product online or whatever, I start doing it in my own name, I will be personally responsible for whatever happens. Now, in principle, that may not entail much, and there are a number of professions who will do so in their own capacity as as a natural person for their whole life. Nothing bad will happen, and if something does happen, there's often also the cases of insurances, especially in Switzerland, where they're quite strong insurances which will cover any damage that could happen. But there is still the chance that if the company does not go well and the business fails, which I have to say statistically happens more often than not, you have to be warned about that. Well, in those cases, well, the founders do not necessarily want to not only having not succeeded as they wanted to, but have to carry on a debt for something bad that has happened, a debt on their personal heads. So this limited liability allows the founders at some point to say, well, we've tried, it was good fun, it was a great project. Fortunately, we could not make it, we could not make the ends meet financially. Doesn't mean that the idea was bad, but financially it didn't work. Then we can just let the company or the entity go. It provides us this limited liability advantage, and so we can start something new. Now, the third point, I've put it between parentheses because maybe a bit of a secondary point, but let's say it's also the social security protection, especially in Switzerland. You may know that as an independent, you are not required to pay, it's not obligatory for you to pay the pension funds, but you can also not at all register yourself as in any capacity in the unemployment insurance, which can prove problematic if you run a startup without incorporating, without registering in the unemployment scheme for 1-2 years. Your previous coverage expires, and if the startup indeed does not work, then you're basically on your own. So in some scenarios, of course, once the startup starts to run, you're happy to also to pay the unemployment insurance premiums. Well, incorporating a company allows you to employ yourselves, which in turn allows you to, if it doesn't work out in the end, at least benefit from a minimum protection. We've just went through the COVID situation, and you see here the difference of treatment between the salaried people and the independent people who at first, during a full month, I believe, during March, were guaranteed no benefits at all because they did not fall within the unemployment scheme, under which all these COVID measures were carried out. So this is, I'd say, another factor which could push you into incorporating or creating a legal entity. So here's the why. Now let's go to the when, because that's also a critical question. Should you, as soon as you have an idea, you shake hands with your co-founder, with your partner, and say, okay, we should go straight to the notary, we incorporate a company, we figure out the name, and we're done with it? Or should you, on the other hand, or instead really push back this step as much as possible? Well, there's no straight answer to that question. It's very project-based, it's very startup-based, depending on a number of circumstances. But I've identified, based on previous discussions or experience, identified 4 cases in which gradually you can feel that the need to formalize the legal entity becomes greater and greater until the point that you cannot avoid it anymore. The first one is to seal the commitment between the founders. I would suggest that you do that only once you have a business plan that's been validated. When I say validated, it's not validated, of course, by your bank or anyone. It's really validated somehow by the market, where if you tested your leads, you've tested your assumptions, there is an interest, and you really strongly believe that there's something that can be done. The reason why I suggest to wait at least until that step is that once you incorporate or create a legal entity, for one, you will need to register the purpose of the entity in the document, and if you need to change it, it is a bit troublesome, let's say, and you cannot change that every 2 weeks, 3 weeks as your business plan shifts if it's not set yet. For two, once you create it, and if in the end you do not carry out your startup because you figure out after a few months, well, better sooner than later, I'd say, but you figure out it doesn't really work, then you still have a legal entity that's running. And you, for the cases of corporations like SARL, SA, or these kind of companies, you have to file financial statements to the tax authorities every year. You have to hold financial accounts, financial statements. So there is let's say, an administrative workload, which may also involve certain costs to pay a fiduciary, etc. And if you're really doing nothing with the company, then you need to liquidate it. And if you need to liquidate it, you'll be paying unnecessary costs, in my opinion, again. This is why I suggest to wait a little bit, at least to the very, very least, until the point in time that you are all reasonably sure that the business plan will work and it's been validated and the assumptions. That's the first trigger, I'd say. The second trigger, sorry, I'm just seeing a question here. I'll just jump back because it concerns, probably saw it a bit late. We have Ilaria who is asking, what about using an association at the beginning to limit upfront costs while receiving some legal status and be able to receive funds? That's a very good point. And I'll get to it actually a bit later when we will be discussing the exact legal forms. And Kyriakos had another question, which is, does an owner of an individual enterprise qualify for unemployment benefits if he is hired by his own individual enterprise? Now, this is an interesting question. In practice, this does not work because the individual enterprise is literally the same person as you, and you cannot sign a contract with yourself from a legal perspective. So there is legally no way to hire yourself, even if you want to, even if you do pay the unemployment premiums, they just won't let you register in the scheme because it's not a situation that's foreseen by the law. The only way to hire yourself would be through a legal entity, either an association, as suggested by Elia, or through a company or other various types of companies or legal entities. You will need one. Then we have Felix. How about founding a society, a Verein, so an association, and offer your service to your juristic members? I'm not quite sure to fully understand the question, but I'm guessing that would be something akin to what we call in French a société de portage. which is basically the individual members would want to provide services to third parties, and they go through an association which hires them as employees, and the association provides the services to the third parties. This kind of mechanism, if I did indeed understand the question correctly, this kind of mechanism will work, and it's fully feasible to do it that way as well. Now, coming back to my when, after this long parenthesis, we talked about sealing the commitment. I'm going to come to the second point, the receiving financing. It can be investments, equity financing, or grants, or whatever we want to call it, but really receiving money for the project. I believe it can be quite obvious in the end, but once you receive financing, the persons providing the financial means will be extremely reluctant just to pay it on the personal bank account of the person. It's not impossible, and it's been done in the past as well, but of course it involves a very high level of trust between the person providing or the entity providing the financing and the person receiving it, because there's really nothing, not even legal obligations preventing the person just to use the money for his own living costs or something else, and then the purpose of the financing is not achieved. So as a general rule, I'd say once you start applying for financing, whether equity financing or grants or donations or whatever, at that point in time, the person providing the financing will very much to see that there is a legal entity on the other side. The third trigger, which would show that it might be time to incorporate or to create a legal entity, is the acquisition or the creation of material assets. I mentioned the example of IP. Now, IP is quite broad, but what I mean by that is probably if you start really developing a large quantity of code in a program, or if you're considering filing a patent, etc., then it makes sense to create a legal entity. Then the fourth item on the list would be when you're ready to go to markets. Here again, it's a question of credibility to the market, to your partners, to your customers, to say, hey, we're serious, we're doing something great here, and we take this seriously, so we're creating a legal entity. This is also something that can come into play.
Thomas, sorry to interrupt you. Can you please speak a little bit louder, because we just got in the chat that your tone is really quiet, if you don't mind. Thank you.
Of course. Is there a way I can turn out the output, turn up the output? Not really. Otherwise, I'll just try to speak a bit louder.
Thank you.
Okay. So now if we get to the types of legal entities that we have in Switzerland, there are mainly, there are more than these four, but in practice, these four are the most often used, I'd say. You have firstly, the corporation, the Société Anonyme, or Aktiengesellschaft in German. You have the LLC, the SARL, GmbH, and then you have the association as well, that we've mentioned before. And last of all, we have the foundation. You can see here that they all serve a bit of a different purpose. If we go through line by line, I'll just quickly go through, because I believe there's quite a bit of material actually on the internet on these topics as well. Whoops, there we go back. You can see for one that the corporation and the LLC, limited liability company, they both have a commercial purpose. So the main purpose, and this is something that's set in the law, main purpose of these entities is really to generate a revenue and generate a return on the investment, that is the share capital. So the purpose, to make it simple, is to make money, right? Then you have the association and the foundation, which are a bit different. The association, the purpose is non-commercial. It's usually ideal. It does not necessarily mean that it cannot have commercial activities. An association would be able to produce, to sell products, to sell services, like consulting, also to rent, to rent a office building, to do, in the essence, whatever a company would be able to do operationally. The only difference is that the association, in the purpose of the association, it has to be something else, something more. It cannot only be to make money. For some examples of behemoth associations that we have around us, you may think, for instance, of FIFA or UEFA, these kind of association organizations, which are also organizing associations. And you can imagine that operationally, at least, they can do really everything that a corporation or an LLC would do. Simply put, the difference is that they have a purpose that is, first of all, to promote sports, football in this case. And in order to promote that sport, in order to reach that ideal purpose, that non-commercial purpose, they have a commercial activity. Then, with respect to the purpose, the foundation, the legal requirement is a particular purpose. The reason for that is once the foundation is created, you cannot very easily change the purpose that's motivating the foundation. So you need to be precise as from the beginning. And it cannot, as a general rule, be, well, the foundation will do everything. It has to be a will of the person creating the foundation to say, well, I want a foundation to help these kind of people, or I want this foundation to manage a certain type of assets. A lot of things are possible, but you need to be specific. You can see on the second line that all these legal entities provide limited liability that we've discussed before. In terms of requirements of persons creating the legal entity, you see that for the corporation and the LLC, you always need one person, one shareholder at least, and you need to go with the public notary. As many of you may know, for the association, it's two persons, but a simple written form. So if, well, we're not in the same room today, but if we were in the same room, we would be able, all of us, or just two of us, create very quickly, within 5 minutes. We sign the articles of association, we sign a general meeting minutes of the general meeting, and then the association is legally created. It does not need to be registered with any kind of authority. The simple act of two people deciding to come together and to form an association legally creates the association, which is something quite rare actually in terms of legal, let's say, legal practice in the world. On the foundation, you do not need a person because the principle is that the foundation is not owned by anyone, but you do need to go to the notary. Going down, the share capital requirements that most of you probably know, you have 100K for the corporation. You can choose to pay a part of it, either 50K, or if you have a higher share capital, you can pay as low as 20% of the share capital. But you have to keep in mind that the shareholders will remain liable to pay up the rest. It's not a discount on the share capital. It's really, we delay the payment of the share capital, and if the company does not go well or has debt, then the shareholder will need to pay up the rest of the share capital. For the LLC, it's lower. It's 20K. For the association, there is no share capital, which also means that you cannot do any kind of equity financing, and there is no minimum contribution as well, which makes probably the most lean, or at least in terms of immediate costs, it's the cheapest legal entity you can get in order to achieve the limited liability. For the foundation, there's no share capital either, but you do need to make at least a contribution of 50K so that the foundation can realistically have a chance of achieving its purpose. This is something that's set by the federal authorities. Then on the board level of these entities, for the corporation and the LLC, you need at least one director in Switzerland. If all founders of the startup are domiciled abroad, then they will still need to find someone, what we call in our jargon, a nominee director or fiduciary director, someone who serves for them and acts on behalf of the founders as a Swiss domiciled director. For the association, there's no requirement for that. So you could have, and you do have, associations where all the board members, the committee members, and as you may call them, live abroad. The association just needs an address in Switzerland. And on the foundation, you need at least 3 board members, amongst which one who is a Swiss citizen and domiciled in Switzerland. Last but not least, you see that on the audit requirement, it's roughly the same for corporation, LLC, association. Below 10 FTEs, or full-time employees, there you can opt out of the audit to delay or to minimize the costs. This requirement really comes in either because you start employing 10 people, or because the entities providing the financing require that you be audited. But it is not always, it's not legally mandatory below 10 FTE. On the side of the foundation, you have to know that the audit is mandatory, and there is, on top of a financial audit, a yearly audit by the supervisory authority, who will want to check that the board members of the foundation are really acting on behalf and in the best interest of the foundation. If we get to the tax exemption, for those of you, we have a question from Ayana, which I'm reading at the same time. And to this end, being a director, it doesn't suffice to be a resident. One must be a permanent resident. For foreign citizens, you need a permit, of course, stay permit in Switzerland. But to my knowledge, I don't think you need specifically a C permit or a B permit to be the local director. I do remember cases where we've registered L permit holders as local directors, but of course, the L permit being limited in time by essence, in the event that the L permit is not extended, then you have a problem and you need to change local director, or at least add one. And the commercial registry will check that, because they share a database with the OCPM, with the immigration authorities. Okay, then we move a bit below to the financing questions, to which we will come back again later. I just wanted to, with this line, to underline something. It's a shame I cannot point at my slide, unfortunately, but you can see on the second line here, at the equity financing. Well, to have equity financing, meaning to interest investors who come in, who give you money in the hope of achieving a return, well, you need to give them something in exchange, right? And this something in exchange is generally shares. If you do not have shares, in the cases of association and foundations, well, there is simply no way to interest or to have this kind of equity financing. One of the basic elements of this concept is lacking. You see below then that for the debt financing, that is possible in all cases. Any one of these entities can legally borrow money. Now, I've added with securities between parentheses, because in practice there is about zero chance that you get a loan straight out of the public notary or right after you've incorporated your company or created your association. All the banks still want to see some kind of income in the company. Then they will take the shares as security. You can go to certain public institutions to oops, let's close this. To get the loan, but in that case also even the public institutions will require that the founders of the startup or of the association sign in their personal capacity in the case that the legal entity cannot reimburse the loan. So there is always some kind of security that is involved because the party lending the money is of course also aware of the principle of limited liability, and they want to ensure that you really do your best effort to reimburse the loan. In practice, however, for the public institutions such as Fondetec, l'AFL, these kind of local institutions, I don't have a feeling, and I don't have cases in mind where they aggressively try to enforce the personal liability of the founders, even though the company failed in the end. It's not an encouragement to fail, of course, but their purpose is really to help and give a chance to certain projects to really take off. And if they get the feeling that the founders really tried their best, and sometimes there are circumstances that you cannot control, you did your best, it didn't work out, they may be a little more understanding, of course, than banks and other typical financial institutions. Then if we go down one level below, I mentioned the donations and the grants, where those type of financing are really mainly thought for association and foundations. Very rarely you will have third parties contributing to a corporation or an LLC in form of a donation or a grant. The last line here, I hope you can all see it, is about the costs of incorporating. We've had a few questions as well asking how can we save up on the incorporation costs, etc. You can note that in Switzerland, you do not need to have a public notary in the place of incorporation. And most of the websites that I'm sure you can find, and I won't name here, which provide these incorporation services, they do that as well. They will use a public notary in a canton which has lower fees and apply it to the whole of Switzerland. But this is something I believe which is in line with what you can expect in the lower range of the market in terms of costs and in terms of time. I'll just mention one word about the association. The association, as long as it does not have a commercial activity or une activité en la forme industrielle, as they say in French, that would be an industrial form of activity. It does not need, there is no obligation to be registered with the commercial registry. Of course, it provides you additional credibility. If you want to, it costs about 400 to 500 francs, and it takes 2 weeks, but it's not mandatory. And you have a lot of associations which are never registered with the commercial registry, and they are right to do so. They're not. It's not illegal. The law fully allows that. We have a question from Rita. How about non-equity crowdfunding? Is it allowed for LLC and AG for the corporation? Now, crowdfunding is an interesting topic. It's a bit of a large concept, which includes several more specific legal concepts, actually. We also talk about use more specific terms sometimes of crowd lending or equity crowdfunding or crowd purchasing, etc. You have to distinguish exactly what is the underlying transaction. Sorry. In terms of crowdfunding, if you sell, I think for instance of Kickstarters, if you sell a product and you get paid beforehand, this kind of transaction is allowed across the board. You can do that with any kind of legal entity, because what really happens in legal terms is that simply you have a purchase agreement over a product as if you were going to your local shop, but instead of getting your product immediately, you pay first and you get it later. And of course, hopefully you do get it at all. Sometimes you can have bad surprises, but it's really a purchase agreement in the end. So there is nothing difficult with that. If we're talking about crowd lending, it's basically lending the money. Then the entity going through the process of crowd lending does not need, in principle, authorization. It depends a bit on the circumstances, but the platform will generally assist and provide general terms that are in line with with the legal requirements. Same for the equity crowdfunding, which means basically that you go to a platform and you don't offer a product or service, but you offer shares of your company. So that would be the equity crowdfunding. So in that case, you need to satisfy a certain number of legal requirements, but those are also and generally taken care of by the platform. I hope that answered the question. If not, please let me know and I'll get back to that. I see the time is running, actually. I thought we would go a bit faster. The hybrid structure that some of you asked about. The reason for the hybrid structure or the thoughts around that is that in Switzerland, there's no specific legal form for ventures with a social purpose, where the purpose is not merely to maximize a return on investment. So what people did and what people thought about doing is to create a hybrid structure, which is really a dual structure, a structure with two legal entities. In practice, that is often in association plus a corporation or a limited liability company. You could also imagine foundation plus corporation or limited liability company or other forms of combinations. But typically for the foundation, it's a bit more rigid, less flexible, and it costs a lot more to put in to set up. So this is not typically the most easy choice, I'd say. But these type of structures also do exist, notably for larger organizations. Now, the pros and the cons of these kind of hybrid structures or dual structures. Well, for one, in terms of financing, the good thing is that you can access everything. You can apply for donations with the association, and you can apply for equity for equity investments with your LLC or your AG. So basically, it's a bit of a two-face structure where you show the face you need to show to the partner in question. There's certainly another advantage in having a hybrid structure is that it can generate a goodwill when you discuss with certain actors in your ecosystem, where you go when you go to talk to them with a typical company, they would not necessarily feel very comfortable, let's say. But if everyone understands that your purpose is not merely to make the most money out of them, but really to achieve a better a common goal or a better future in one way or another, then they might be a lot more keen to talk to you. The third thing, from an operational point of view, is that they can mostly be managed by the same persons. Now, there are certain small restrictions that are linked to the tax exemption of the association if the association requires one. But mostly, you do not need to think that once I have the hybrid structure, we need 10 people to manage it. No, you can manage it with 2-3 people as well. It can work that way, provided that we keep certain things in mind. And I'll get to that. And the fourth advantage is that also from an operational point of view, nothing prevents you from starting with an association or a corporation or LLC and creating the other one afterwards. If you planned for it, it's very easy to do. But I would suggest that you keep that in mind as from the beginning, because if you don't plan for it, then it's hard afterwards to distinguish the two entities. Now, in terms of disadvantage, the main thing I'd say in the beginning is really the amount of admin work, because it is two separate legal entities, and you need to each year do 2 general meetings. You need to do twice the accounting. Even if you do transactions between your association and your company, and you're on both ends somehow, you still need, and it is very strongly recommended that you leave a paper trail for that. The reason I'll jump a bit here is that as a manager or as a director of each one of these entities, you need to ensure that you defend each one of these entities' best interests, which is a bit contradictory. You can't negotiate with yourself at a certain point. So Swiss case law has come up in relation to also to other main tax issues, they've decided to follow the general principle of arm's length, which is a global, I'd say, legal principle. The meaning of this principle is that whenever you deal with an entity that is close to you, you need to keep that entity at arm's length, meaning that you would and you have to treat that entity as if it were run by a third party, by another person. So it means in practice is that if you make a payment from your association to DSL for a certain service, then the price of that service has to be market price. You cannot vary the price according to the cash flow level, whether one entity needs money more than the other, etc. It's not left pocket, right pocket, and we're all happy behind it. Because if one of these entities does run into trouble at some point, someone might, get a peek into what happened exactly, and if they see that money was siphoned out with no interest to that entity, then it is literally a crime to do so. So this is very important. Running a hybrid structure requires a tremendous discipline to ensure that the arm's length principle is fulfilled at all times. I took my purpose an example where it's quite easy to comprehend, but these situations can get a bit trickier. For instance, if you have an employee, how would you qualify the 5-10 minutes or 30 minutes per day that he may go to the mailbox, pick up the letter, and you have your two entities who get their letters delivered to the same mailbox? Is that okay? Is that not okay? There is not a straight answer to these kind of questions, because the more you mix in the interest, the harder it is to segregate each one of the interactions of your daily life. But as much as possible, I'd say it is important, at least for the payments, for the financial side, to keep a very strict track record and to keep all the documents in line with the arm's length principle. Another disadvantage, I'd say, is what I've seen with entities who've been running this model for a couple of years. I have to say there is always a constant shaping of the missions of each entity. Because you have two entities and you need to explain that to your ecosystem. If you don't explain it, it just looks very opportunistic. If you go to your stakeholders and say, hey, you're nice, I'm going to be the association for you, and you're not nice, so I'll be the corporation. I will just profit from you and make a lot of money on your back. This doesn't work. You need, of course, to have a proper mission behind it. You need to have values. You need to distinguish what are the things that are part of one entity's work and what are the things that are part of the other entity's work, and where do we draw the line. And this is a moving line, and you need to it requires a certain amount of work, of thought, of consulting, of talking to your partners, to always keep that line in a way that makes sense, basically. So this would be the three cons. At the end of the day, it really depends on what makes sense. What makes sense in terms of structure to you. If you have a startup whose purpose is perhaps to sell a very high technology or high value added product in the end, or have high value added service with little or no connection to social missions, not saying that it has to be bad, but it really depends on whether there is a direct connection. If there is no direct connection, then it probably does not make too much sense to spend time in considering these kind of structures. If you do want to have a social purpose, a purpose that can only be achieved by a non-commercial entity, then it's something worth thinking about, I believe. Especially now that we also have a bit more experience in managing these kind of entities, and we're also reassured by the responses of the authorities, who seem to tolerate this, even though it's not quite conventional. We have a question from Ayana. What about eligibility to grants in this context if they require a non-commercial entity? Well, this is exactly the purpose of the hybrid structure at the end of the day. For instance, let me give an example. You can have a project which wants to offer an open source software to everyone in order to further some social goals. And on the other hand, they will provide, for instance, a value added service on top of that open source project. And this kind of services would be paid, because the developers, they act as consultants. They would go to the client's premises, install, develop, and or I don't know, develop new functions and roll out these additional software. In those kind of circumstances, you could fully imagine that the open source part of the project gets financed through grants from various entities, and that the business side runs independently. And this is really the core aspect of the hybrid structure, is that you can kind of separate the various aspects of your project. If you do that, if you do everything in one entity, for instance, if you do all that in a commercial entity, then there is some tension to the fact that your shareholders will not necessarily be happy that the board spends too much money on an open source project, which in itself does not bring any return on investment. You can have, of course, shareholders which are fully understanding, and I would, of course, encourage you to find these shareholders. But in principle, the legal structure is constructed in such a way that the shareholders, they will want, and they have the mechanisms to enforce their better interest, which is an interest in money. But this is why you can imagine these hybrid structures, and they allow you basically to go seek financing, various forms of financing, depending on the project and on the type of activity that is financed at the end of the day. I hope that answers the question. I'll move on for now. A quick word, because I see the time is really running, about differences between debt and equity financing, and on the convertible instruments. Now, this is mainly directed at the startups in a form of corporation or limited liability company. If you borrow money, you know that you pay a fixed cost for the money borrowed, which is the interest. These interests are deductible as costs from a tax perspective, and you pay less tax on the benefits if you do have benefits. And there is basically no benefit sharing. If you make more, or you have a better return on your capital than expected, you don't pay a fraction, but you pay a fixed cost. The debt is also advantageous in terms that it has a low setup cost. You need to sign a loan agreement, which most entities lending the money will have, and they will enforce their own templates anyways. So it's quite easy. You sign, you get the money, and you can start using it and paying the interest. On the other hand, you don't really have a strong alignment of not the money interest, but the factual interest between the entities, because the banks, but also like the other entities lending you the money, well, their main interest is that you pay them the regular amounts, and you pay them the capital at the end of the term. So this is what they want at the end of the day. Whereas in terms of equity financing, since there is a sharing of the profits, a sharing of the control as well, you need and you will have a much closer relationship with your shareholder, who are on the same boat as you are in the end. Because if the company does not work, they will lose their investments as well. So it's not as it's a closer relationship. Now, there is a way. Sorry, I forgot to mention, equity financing is more costly. There's higher set of costs. You need to perform a capital increase, go back to the public notary. You need to sign a shareholders agreement in most cases to structure the relationship between the shareholders. So it's a bit more heavy and takes more time. It probably takes 3 to 6 months, unless you know the investors, the shareholders very, very well. There is a way to kind of jumpstart this whole thing, where you would start with convertible instruments. What are convertible instruments? They start out as loans, but the loan amount after a certain point in time, or depending on certain conditions, will be converted to shares. This is mainly used for investors that you want to onboard as shareholders, but you do not necessarily want to pay the 10, 15, 20K that's required to perform the capital increase, sign the shareholders agreement, and do all these steps, which are also on top of that very time consuming. So you don't want to do that. You just need to access the money very quickly, because perhaps you need to make research and development, pay your employees, make your startup run, and you need the money within the week. In those cases, you can consider and negotiate a convertible loan. This is probably the most flexible tool of all. I'm getting to the last part of the presentation, which is intellectual property. Very briefly, we have 4 types of intellectual property for big types. You have patents. Patents are for technological innovations. So you need an invention that is new. And in that respect, it's of course very important that the invention not be disclosed beforehand, because once it's out there, it cannot be new anymore, and you know that your patent request will be rejected. And even if it is by mistake approved, it could still be cancelled afterward by any courts. You then have the design, which protects the novel and original shapes and appearances, typically used in connection to watches, to the iPhone. They did design, they filed for designs as well for cars. Basically, anything that looks original and nice in terms of exterior appearance. I'd say those 2 types of intellectual property are very industry specific. So if you are in those industries, you would generally know that you're concerned by them. Then you have the trademark, and trademark is something that really, I'd say, applies to 90% of the startups, and I feel that perhaps people often overlook, because it's thought it's considered as an extra cost, not really necessary. But if the startup does perform well and it does work at the end, then sometimes it's too late to correct this mistake afterwards. The purpose of the trademark is really to distinguish your product or your service on the market, meaning that you launch a product, you launch a service, you put a lot of effort into it, and you just, I'm laughing because of the comments, but you put a lot of effort into it, and suddenly you see that someone else just has a similar website with the same concept, same everything, and it's really frustrating. And we've seen that, and you can really see that quite often actually, because it's the market. If there's no price to pay for someone to copy another person, then why not at the end of the day, right? So people do use trademarks to protect them from these kind of situations, so that at least if the other person wants to have a competing activity that's very similar, they need to use another logo, another name, so that there is no chance of confusion between their products, their services, and yours. The products and services are distinguished in a list of classes. It's Nice classes, not Nice. Nice as the city in France where the convention was negotiated. Basically, you have various classes. You can go online on the website of the WIPO, and if you type in bread, for instance, you will see that there's a class for bread, there's a class for paint. Almost anything that you can think of will fit into one of these classes. And you can only protect the trademark with respect to a certain number of these classes. The more classes you apply for, the more costly it is. Getting on costs, in Switzerland, to apply for a trademark on your own directly with the authority would cost, in terms of administrative fees, 650 francs for 10 years of protection, or of registration, I should say. So it's up to you, but I think in the end, if the startup does work, it's not an excessive investment, I'd say, for this kind of protection, especially considering that it's really first come, first serve. So if someone else does file for your logo or your trademark instead of you, there is no way you can prevent him, even though you're using it before. Your only right would be to continue using your logo, which is trademarked then by someone else in the same scope and in the same areas as you used it before. So it means that you're effectively limited in your expansion opportunities if that does happen. It's for all 10 years, the amount I said, the 650 francs. It's the online application. It's for 10 years. After 10 years, you have to pay a renewal fee. I'd like to perhaps mention now another topic is that, especially in respect to the trademark, the legislation is always national. So when I'm talking about 650 francs, then it's Switzerland. It's not worldwide as is mentioned in the chat. So if you do want a worldwide protection, it would cost probably a lot of money to do that, and really only the big corporations will have the teams, the manpower, and the financial means to protect the whole world. What's usually done is that you would typically focus on your production site and on your markets to know where it's really relevant to file your trademark. For instance, if I produce my goods in France and I sell them in Europe, including Switzerland, then I would probably file a Europe trademark plus a Switzerland trademark, and that's it. At the point in time where I want to expand to South America, for instance, then I will consider filing the trademark there at that point in time. Otherwise, there's also a rule that says if you file for a trademark but do not use it for 3 to 5 years, depending on the countries, then the trademark is effectively cancelled. They won't deregister it, but if you do try to enforce it, the opposing party can always say, well, actually, you did not use it, so your trademark is really void. This is also one reason why people would not file for a worldwide trademark right away if they don't plan to roll out their product all over the world immediately. The fourth and last category of intellectual property would be copyrights, which covers any kind of original creation. We're talking about books, music, stories, interpretation, voice acting, all these artistic content. And it includes, it is a bit of a quirk in terms of legal way of thinking, but they've included at the time also the software into the convention, which means that the software is protected as a copyright, as many of you probably know, which also makes the protection of software extra difficult, because as soon as you change the coding with exactly the same functions, the same appearance, etc., then it's not technically a copyright infringement. Now, the takeaways for the intellectual property, I believe, should be, for one, that all the legislation are national. So if you want to consider a protection in various countries, you need to think of the legislations of these various countries. Now, if you go to an IP lawyer, they are fully aware of that, and they all work in global networks, so that you can carry through with the protection across several countries. The second thing is, it is a costly and not an automatic enforcement, meaning, and I've been accused of being imprecise and of lying for that, because we always talk about IP protection, but it's really not a protection. You need to actively enforce it yourself, which costs money and which is probably money that you would not have as a startup when you start, when you just incorporate your company. You need to, if you see someone on the market that is infringing a trademark, for instance, you need first probably to send them a letter on yourself. If it doesn't work, if you don't correct it, you might need to go to a lawyer to send a letter and to file a suit. It is costly, but I would say that filing a trademark, you can't say that because of that the trademark is useless. It's really it's sending out a signal, and it's giving yourself a chance to fight it if it's worth it down the line. Of course, if you, as a startup, it's a big world. So if as a startup, you suddenly face one of the mega corporations of the world who decides to, just roll you over with a lot of cash, then, there's also little you can realistically do at some point. But at least you give yourself a chance to fight. And the last takeaway with respect to intellectual property, I'd say, is the licenses. The license is the owner of the intellectual property deciding to authorize a certain use under certain conditions of his IP to a third party. Licenses are contractual, so it means that you can really have any kind of licenses that two parties sitting in a room can think of. It's very variable. You can everything is open to negotiation, and there is really very little very little mandatory rules on what you can or cannot do with a license. As long as you have a license agreement or you have a document that says you can do it this way or that way under these conditions, then it's authorized. We had one question by email where it was about the use of I'll just skip to the last slide here. The use of online materials on the third item that were published by a third party. I believe that the third party had license terms on its website, depending on whether it was commercial or non-commercial use. They authorized broadly all non-commercial uses, and for commercial uses, from what I understood, you needed to contact them to check with them. So typically, this is also valid from a license point of view. It's a contract. So if the owner of the IP tells you, well, you can use it for non-commercial purpose, and of course, as long as you have a non-commercial purpose, you are free to use it. This is maybe a bit of a professional overkill, but I would save a copy or a PDF of the website in case they change it afterwards, if I were really cautious. But generally, it should be okay. I should mention also in relation to that topic that there are data banks of pictures online where they explicitly say that there is no copyright on these pictures, meaning that you cannot get into trouble for using those. Of course, the pictures might be different or less pretty, or this is something up to for you to judge. Two last topics, answering the questions that were asked by email. At times, I got questions on how do we get the founders to concentrate on delivering value and not to fight internally. That's very hard. And most startups actually fail not because the product is not good, but because people cannot agree on what and how to do it. So this is something, of course, it's more about interpersonal skills, about leadership, about a lot of other things, but not really legal things. I believe it's about alignment and realignment and discussing on these things regularly. From a legal perspective, my very basic recommendation would be that there be a serious talk about the ultimate goal of the venture, how the founders see the future of the company, whether they see it in an IPO in 5 years with 200 employees, or whether they see it as a local company, very close to the community, where the founders are personally involved, etc. These kind of things can really give a feeling on whether the various founders are on the same page or not, or at least make you aware that there are certain differences in views. Once that discussion has happened, then I would suggest that either you go to someone, a lawyer, to have a shareholders agreement drafted up based on your discussions, so that you also have certain safeguards on how the shareholders would act with respect to the project, or, and it's perfectly valid, I understand this choice as well, if you do not want, or it's too early in the project, then I would suggest that the founders just write down in bullet points what they've discussed, what they've agreed on, and even the things they do not agree on for the time being, but that are open for discussion, that you can leave for later, but that you basically have a written document on this that you can reuse in the future. Reuse not necessarily in the sense that we want to enforce it, but reuse as say, like, hey, this is where we left it off. You change your mind, or we change our minds. Why did it happen? And to help you understand what happens in this whole process. If you want something that is enforceable, however, you will need to have a shareholders agreement, because under Swiss law, at least for the corporations, the Articles of Association cannot enforce particular obligations on the shareholders. The shareholders can only be obligated to pay the share capital, which they do when they incorporate, and after that, the Articles Association can foresee nothing more. That's why we do shareholders agreements. Very, very last point, because I'm probably going to run over my time, or have already done so. The saving of the legal costs. My view on this personally is that probably for startups, a lot of legal costs are unnecessary at first, meaning that you might not need 10 types of contracts for every situation that you could imagine facing when you start your company. I would suggest to proceed in a very practical way. Meaning each time you discuss with a major partner for a material asset, etc., then you think, okay, do we need a very formal contract for that or not? If so, well, maybe you need to consider the cost. If not, there are also a lot of things available as resources on the internet around you. Maybe you have friends, but these kind of things also work. A contract at the end of the day is really a meeting of the minds. As long as two people agree with each other, you have a contract. So it's fully valid for two parties to sit down together to say, okay, what do we agree on? You pay me this, and I will provide you that. Okay, fine. By what date? Okay, we agree on the date. When do you pay me? Okay, we pay on this date, etc., etc. And this kind of very basic contract, which will cost you very little, will effectively provide you a lot of protection already at the early stages. And perhaps one last comment is there are a lot of alternative offerings as well online, including in the legal world, but I'd say generally. One last bit of recommendation here is that if it's really free or cheap, it probably means that you're the product at the end of the day. So you need to consider that as point, that privacy, etc. I think that's all on my side. Of course, if there are more questions, I'm happy to take them even on other topics. While I wait to see if there are other questions, I see that Rita asked a question about patents and how much that costs. This is honestly something I could not say, because patent law is something very specific in which with which I'm not familiar. I've heard numbers which are generally never lower than I'd say five figures, to the very, very least, even to the 6 figures. So this would probably give you an initial hint. But if you are in the field of patents, you might also be in connection with one of the universities in Switzerland. And the universities, they have these technology transfer offices, which are generally also the ones competent to help you file the patent. They do so on their side as well on some occasions.
Well, thank you so much, Thomas. We are running a little bit over time, yes, but it has been really insightful. It has been eye-opening, and I'm sure that the participants will keep on sending their questions to you. On that note, on behalf of everybody who is here, thank you so much. Thank you on behalf of the Incubator, and we are looking forward. I am having trouble with my connection today. I don't know if I'm still with you, but next time we are going to have Christoph Birkholz. He's going to tell you all about fundraising. As you may know, Christoph Birkholz is the co-founder of Impact Hub Switzerland and Impact Hub Zurich, and he, together with other people who are raising funds, are responsible for us being here together and having some money to operate. So he's definitely going to share his secrets with you. Do send him your questions. I'm going to post his email, and I look very much forward to seeing you next Friday during our Lunch and Learn. Thank you very much for being here, and have a nice afternoon and a lovely weekend. Bye, everybody. Bye, Thomas.
Thank you. Bye.